So, how involved in intellectual property is your CEO? Well, in the past, the IP department has been the domain of the lawyers, and if we are really honest with each other, the executive members of the board didn't get too involved. But all of that's changing, according to Rob Sterne, the industry veteran who's in conversation here with IPBC Global's Richard Lloyd.
One of the interesting things for me is how involved the most senior level of management at Phillips is with intellectual property. Typically, my experience has been that the senior management of companies of all sizes are not that informed about intellectual property, nor do they seem to perceive it as something that they need to worry about or master. And what I found interesting about Phillips through Rude Peter's work over the years is how much focus Phillips has placed on intellectual property as a major decision-making tool and as a major metric that they observe as they run their company.
Do you see similarities with American multinational companies?
I think that American multinationals, and it depends on the industry, but for example in electronics, I think there's a much greater emphasis on the intellectual property landscape than there was, say, 10 years ago. Now, of course, in the United States, pharmaceuticals and other industries that have historically relied on patent protection or trade secret protection as key to their business model have always embraced intellectual property. But there have been many portions of the US economy, such as electronics and consumer products, which have historically not really worried about intellectual property. And there's definitely an increase in the attention that they're paying.
And for those companies, how would you assess the current legal landscape in the US for large patent owners?
Well, large patent owners, I think, are questioning the investment because the value of patents overall seems to have decreased over the last several years with the new law, the American Invents Act in 2012, and then also possible additional legislation that is currently being considered. The net of this is that large companies in particular are looking at the huge portfolios that some have built and asking themselves the very real world question, how can we capitalize on this portfolio? Should we spin it out, for example, as a separate entity? Should we try to license it more or use it in other business ways to create immediate value? So there's a lot of questioning that is going on amongst corporate decision makers about large patent portfolios today.
Yeah. To look at your own practice, you obviously focus on a lot of post-grant proceedings with the USPTO. How would you assess the climate currently for companies facing those proceedings?
Well, there's no question, Richard, that the U.S. patent landscape has changed dramatically since 2012, when the new contested proceedings became operational in September of 2012. There has been over 1,500 of these new contested proceedings filed since September of 2012, which is about 2.5 to 3 times what the U.S. Patent and Trademark Office was expecting, or what was expected when they wrote the law in 2010 and 2011. So it has put a huge increase of work on the patent community, and it has changed dramatically the ability to enforce, the ability to license, the ability to monetize, the ability to transfer patent rights in the United States. It's been a fundamental change, and we don't fully appreciate the full impact of it yet, because these new contested proceedings take time to go through the process.
Yeah.
And so it's a work in progress.
Do you see the USPTO stance softening at all?
As you know, the statistics for the first wave of proceedings were very daunting for patent owners. 80% of the claims that were challenged for the new contested proceedings were instituted for these proceedings on at least one ground. And of those that were instituted, 95% in the first wave of proceedings were found to be unpatentable based on the challenge that occurred. So from a patent owner's perspective, these statistics are very scary. And it's had a major impact on the licensing, enforcement, monetization of patents in the US based on this new development.
In this context, for major brand owners, how significant is the rise in design patents?
Well, design patents historically in the United States were not that important. But with the cell phone wars in particular, and with some other celebrated cases in consumer products, what we have seen is a heightened appreciation for the use of design patents to protect innovative product designs and innovative graphical user interfaces in consumer products. In addition, the use of trademarks continues to be extremely important for corporate value because in many situations it's the brand power that is the most valuable asset of a corporation. The brand that the company enjoys, and in a mass marketed consumer products industry environment that we find ourselves in today, the brand rights are extremely important for commercial success.
And finally, from your perspective, what advice would you give to a company looking to grow its patent portfolio in the US?
Well, I think that there is a definite move towards quality. We see over the years a real emphasis on numbers, and many of the large patent owners drove the cost of obtaining protection for their patent rights way down. But quality has become a much more important metric based on these new contested proceedings, and also based on the overall decline in power and importance of patents in the U.S. economy in the courts. Yeah. So there are some major developments that are occurring.